Welcome to the Jeremiah Patterson Show. We are continuing with several different breaking news stories here tonight as we continue to follow everything for you. First of all, we have some breaking news coverage here. The federal judge in the Northern District of California, it is Judge Charles Breyer, has ruled essentially that the Trump administration's federalization of the California National Guard is illegal, and it has to end. This is from his ruling here. Quote, on June 6, 2025, the federal government initiated immigration raids across the city of Los Angeles. Protests swiftly followed, and some individuals involved in those protests were unruly and even violent. State and local law enforcement responded. The following day, President Trump ordered that members of the California National Guard be federalized and thereupon assumed control of those forces. At this early stage of the proceedings, the court must determine whether the president followed the congressionally mandated procedure for his actions. He did not. His actions were illegal, both exceeding the scope of his statutory authority and violating the 10th Amendment to the United States Constitution. He must therefore return control of the California National Guard to the governor of the state of California forthwith. This is the conclusion here. For the foregoing reasons, the court grants plaintiffs' motion for a temporary restraining order. Defendants are temporarily enjoined from deploying members of the California National Guard in Los Angeles. So he's talking about the defendants here are temporarily enjoined. He's speaking about, the federal government here, essentially. Defendants are directed to return control of the California National Guard to Governor Newsom. The court further stays this order until noon on June 13th, 2025. Plaintiffs are ordered to post a nominal bond of $100 within 24 hours. The bond shall be filled in the clerk's office and be deposited into the registry of the court. If said bond is not posted by the aforementioned date and time, this order shall be dissolved. Defendants are further ordered to show cause why a preliminary injunction should not issue. A hearing on this order to show cause will be held on June 20th, 2025 at 10 a.m. Plaintiffs' moving papers shall be filed no later than June 16th, 2025. Defendants' opposition shall be due no later than June 18th, 2025, and plaintiffs' reply shall be due on June 19th, 2025. It is so ordered. The date signed is June 12th, 2025. Charles R. Breyer, United States District Judge. So, of course, this ruling comes as we are watching this live situation happen. Earlier this week, last week, Donald Trump federalized the California National Guard, overstepping the governor of California. So he federalized 2,000 troops to California to go to Los Angeles. Only 300 actually showed up. 700 Marines, in addition to that, have also been mobilized to LA. And the National Guard that is in LA, as well as the Marines, they have been tasked essentially with just, sitting around, protecting federal buildings there. But I mean, we're also facing the situation where we're getting reports of National Guard members assisting ICE immigration officers, as the Secretary of Defense, Pete Hegseth, is tweeting stuff like this. National Guard members assisting federal immigration officers on their ICE raids as they go and they complete their missions. It's deeply, deeply concerning here. I mean, we've all seen the video of concerned protesters and Congresswoman Maxine Waters concerned about the fact here of what the National Guard is actually going to do. I mean, you're being deployed against your own citizens in this country. What does that look like? What does that mean? There are so many questions that have filled my mind with this. And for one, it is completely vituperative and repulsive that our National Guard was deployed and now they're sleeping, on the ground because there was no funding for them. And also their health benefits are in limbo because this administration just decided to send them for no reason. They did not need to be sent. Los Angeles is a huge city. They have more than enough law enforcement. And the law enforcement already came out their mouths and said these were peaceful protests, with the exception of a couple violent demonstrators. You have escalated this situation. And so we see today this order from Judge Breyer essentially saying, hey, this is illegal. Judge Breyer also said in this incredible ruling here, he talks about essentially the fact that the United States here, with regard to this, he said essentially that the United States, quote, we live in response to a monarchy. That was one of the things that Judge Breyer said in his ruling here. I said, quote, "We're talking about the president exercising his authority, and of course, the president is limited in his authority. That's the difference between the president and King George. We live in response to a monarchy. Line drawing is important because it establishes a system of process." In the lengthy decision, according to the LA Times, Breyer wrote that he is troubled by the implication inherent in the Trump administration's argument that protest against the federal government, a core civil liberty protected by the First Amendment, can justify a finding of rebellion. Quote, "I'm trying to figure out how something is going through somebody if in fact you didn't send it to him. As long as he gets a copy at some point, it's going through." So essentially, this is the judge here appearing, questioning the Trump administration, which essentially has cited Title 10 of the United States Code to justify the takeover of the National Guard. But that provision, as the judge noted, requires that orders from the president, quote, "shall be issued through the governors of the states." You can't just federalize the National Guard if you don't like what something is going on in that state. And I mean, look at the Secretary of Defense on this. The Secretary of Defense, Pete Hegseth, this is his response to being asked, what is the justification for this? He was asked about this earlier this week in Congress.
On a couple of lines of questioning, just specifically, Mr. Secretary, what is the authority that the administration is using to deploy active duty Marines to California neighborhoods? What authority?
Senator, the president has constitutional authority in order to support.
Cite the provision of the Constitution.
I'd have to pull up the specific provision, but our Office of General Counsel, alongside our leadership, has reviewed and ensured in the order that we set out that it's completely constitutional for the president to use federal troops to defend federal law enforcement.
So as we are contending with all of this at once, I have more questions than I can present to you in the best way I can. I hope I've laid this out in a way that is understandable and digestible, but I have lots of questions. So I reached out to a former JAG lawyer, a professor currently, Professor Rachel Van Landingham. She's on the Jeremiah Patterson Show tonight to make sense of all of this, and this was our interview earlier today. Joining me now for the interview is Professor Rachel Van Landingham. Thank you so much for coming on the show.
Thank you for having me, Jeremiah.
So for our audience who may not be familiar, can you briefly explain the Posse Comitatus Act and what it does?
Sure. It's an old federal statute that started in the just before the basically during Reconstruction era following the Civil War, that prohibits federal troops, that is the active duty military, as well as National Guard units who normally work for their state governor, but if they're federalized, they work for the president and they're indistinguishable from active duty members. It prohibits federal troops from being used as a police force on our city streets. And the reason it prohibits it is because there's a long-standing tradition going back to our founding fathers of not using federal troops on our city streets unless it's an absolute emergency. And the reason being, just like the founding fathers stated in the Federalist Papers when they were arguing for the Constitution, is that using the military against we the people is a tool of tyranny. It's a tool that authoritarian leaders use, and it's one of the reasons that the colonists, the American colonists, fought off Great Britain, fought off King George III, because he was using his military, the Redcoats, to basically terrorize political opponents and to repress civil liberties here in the then colonies.
Now, the president has not invoked the Insurrection Act. We've getting reports of like National Guard troops being ordered to cooperate with, ICE agents for domestic immigration operations. What would that look like? I mean, I know the Insurrection Act has not been invoked, at the moment, but what does it look like for National Guard troops to be doing actual law enforcement stuff on the ground? And is that a violation?
It looks like illegality, and it looks like something they should be refusing to do. Because to put it in context, right, the Posse Comitatus Act prohibits federal troops from engaging in law enforcement, which is what Posse Comitatus means. And we've got some case law helping explain what those parameters are. But there are exceptions. The exceptions are, the most typical exception is the Insurrection Act, which is an even older assemblage of statutes. There's about 5 statutes that give the president categories which when he recognizes these categories are in existence, that he can therefore use federal troops in a policing capacity. But it's a very formal process. He has to issue a proclamation because it's supposed to remind the president that this is really rare. It's dangerous. Use this power sparingly. There's a formal process. We govern by rule of law here, not by military force. So right now, these federalized National Guard members who are indistinguishable legally from active duty members and the 700 Marines that were sent in to Los Angeles are supposed to be exercising purely protective power. What does that mean? It means that there is inherent power the president has under Article 2 of the Constitution to protect federal property, federal personnel, federal assets. And the court has recognized this inherent authority, but in a narrow fashion, being that, yes, the president can deploy the National Guard, who are federalized, as I saw them downtown in Los Angeles this week when I was down there, around the federal detention facility, around the federal building, and they can be very reactive, right? They can protect, and if they're going to have to push someone away or actually temporarily seize somebody, they better turn them right over to the Los Angeles Police Department because they don't have arrest authority. And that seizure better not be because they're being proactive, but purely reactive and protective. It's a very narrow protective function. However, as the reports are coming out, there are National Guard members being ordered to accompany ICE agents as they're engaging in their federal law enforcement function, as they're executing warrants, etc. If we have federal troops sent to protect federal law enforcement agents, why they engage in law enforcement, that is law enforcement. That's no longer pure protection, and that therefore violates posse comitatus. They're engaging in law enforcement if they're escorting ICE agents on ICE agent duties. And therefore, if the president actually thinks they need to be doing that and he wants to do it lawfully, he needs to invoke the Insurrection Act, which actually really would be, a huge step away from the times when the Insurrection Act has actually been triggered and been invoked. And why? Is because it's supposed to be sparingly, break the glass in case of emergency. There isn't that emergency. And so it seems like this militarization has been based on fabricated excuses in order to portray like a very, strong law and order message. But the damage it's doing to federalism, to the division of power under the Constitution between the state and local government and the federal government, and the danger and damage it's exposing our troops to and our law enforcement on the ground by having all these folks that are doing different missions at different times, and the danger it's doing and the danger it poses to military members, right? I mean, these National Guard members, now totaling almost 4,000 that have been federalized by the president. They weren't sitting around waiting for him to be federalized. They're not active duty. They're working, going on their daily jobs, going to school, going to work, picking up their kids, eating dinner with their family at night. Now they've been wrested away from their families, but not based out of necessity, based on some show of force. They're sleeping in buildings downtown without shower facilities. That's so disrespectful to our
Yeah.
to our military members. And again, it really highlights the fact that our military should not be used as a domestic police force on our streets unless it's really necessary. How do we know it's necessary? Because the governor would ask for it, right? And I mean, outside of just the pockets of violence that have occurred along with some of the protests, but the LAPD, which numbers in the thousands, we're the second largest city here in the United States. We have a huge law enforcement capacity and capability. And the mayor actually called for a curfew that's been ongoing for the last few nights, and that's really helped tamp down any kind of the gratuitous violence that often accompanies the exploitive violence, the agitators that have taken advantage of the situation. And so we really are living in some unprecedented times. And right now we've got a federal judge hearing arguments as we speak on the challenge to the legality of the president's order federalizing the troops in this fashion.
I wanted to ask you here. I know that we're getting reports that morale among the troops is down because of the situation with them sleeping, on the ground, and there's no funding for them. What role, if any, do military lawyers essentially play in advising on these type of domestic deployments?
Honestly, very little, except at the very top, because the Department of Defense has a civilian general counsel who advises the Secretary of Defense, and that civilian general counsel is a political appointee and was put in that position because they're a yes person, just like most of the political appointees in this administration are. And so the military lawyers on the ground are advising on, the tactical execution, legality of the tactical execution. But there is a role for the military lawyers to step in and say, hey, boss, you're being told that you have to send these National Guard troops to go accompany ICE agents on ICE raids. That's unlawful, and you shouldn't be following it. I mean, that would be the advice I would hope these military lawyers would be given. But again, you're also putting them in a really difficult position of saying something contrary to what their own chain is saying. And why is their chain saying something different? Several months ago, Secretary of Defense Pete Hegseth removed out of cycle the top military lawyers from the Air Force and the Army. Even though their positions, by the temporal duration of their positions, were protected by statute, he just removed them. And he admitted during an interview that he removed them so they would not be obstructions to them, to him. Well, they're supposed to be given their unbiased, non-political legal advice. He doesn't want to hear that. He just wants to hear yes. And so I would not be surprised that these lawyers are all getting the advice from their from their lawyer chain. Hey, this stuff is all fine. Because again, we have monkeying around with the top lawyers within the military. But good military lawyers on the ground will look at this and say, okay, this is law enforcement. If we're going to actually engage in, help execute raids, because we're protecting the law enforcement agents who are engaging in these raids, and therefore that is law enforcement, and you shouldn't do it. But because this situation is so unusual, we have not seen troops that have been federalized, the National Guard federalized, without the Insurrection Act being invoked. Because usually if the emergency requires federalization, the emergency requires policing action. And yet the president's claiming that there's such an emergency, but he hasn't taken the proper legal step to actually use these troops in the manner in which a true emergency would necessitate. Interestingly and ironically, the National Guard is dual-hatted. They typically work for their governor. They used to be called the militia. They've been around since the beginning of our nation and helped fight our Revolutionary War. When they work for the governor, they have law enforcement capability. It's one of their mission sets. They're there to help respond to natural disasters, provide disaster relief, and augment law enforcement when needed. But when President Trump wrested away these National Guard troops from Governor Newsom, he took away their law enforcement authority. Yet he claimed that they needed to be there to enforce law and order, which just reveals the chimerical, just the really disingenuous basis and rationale for the president federalizing these troops in the first place.
Once again, thank you so much for putting this all into perspective. I've been so perplexed by what's going on and understanding it. So, once again, my guest tonight, Professor Rachel Landingham, I really appreciated your time. Thank you.
You're welcome. Have a great afternoon.